This is Carrie Washington weighing in on yesterday's ruling by the Supreme Court on ex-presidents having immunity from prosecution. So what does that really mean? The layperson like myself is thinking he can commit any crime and get away with it, like unaliving someone or ordering the hit on any dignitary, because this is far-reaching. It's changing the course of our democracy. Justice Sotomayor did not agree. But before we hear from her, let's listen to what Carrie Washington, the actress, has to say.
So yesterday, the Supreme Court ruled that the president is immune from criminal prosecution. So I'm going to say something right now that may sound extreme to you, but this is not an exaggeration. Please listen to me very carefully. This decision is a blueprint for dictatorship. This decision lays the groundwork for a president to do whatever they want, whenever they want, to whomever they want. And the only thing standing in the way of that happening is you. Your voice, your vote. Okay, let me explain. So, according to the Supreme Court, the conservative court that was made possible by Trump's first term in office, according to that court, the president of the United States is now immune from criminal prosecution for actions he takes as a president while in office. So what does that mean? Well, as my sister from the Bronx, Justice Sonia Sotomayor, explained, and I'm paraphrasing, but she said that that decision means that Trump could order the military to kill a political opponent with zero consequences. So this is how democracies in other countries have failed in recent years. It's not by wars, it's not by coups, it's through elected governments using methods to chip away at the power of the people until we have no power at all to hold those governments accountable. So if Donald Trump is reelected, there will be very little that we can do to stop him from using the power of the White House however he wants. There are reasons to feel frustrated with our democracy. I get it. I feel it. We have a long fight ahead of us to have this country really live up to its ideals. But this year, I am telling you...
As you come on to the page, kindly hit the like bell and subscribe to the channel if you haven't done so as yet. And don't forget to put on the notification bell so you can be notified when I drop the next video. Thank you.
This year, I am telling you, our actual freedom is on the ballot. And I am terrified that the belief that too many of us have that our votes don't matter could mean that one day in the very near future, they actually won't matter at all. Now, I'm not saying this to scare you. I want to inform you. I want to remind you of the power that you do have. Right now, it is not too late. You have power. You can share this video with friends and family and loved ones. I think voting is an act of self-love, of self-care. Voting and volunteering, donating to organizations that fight for democracy. These are the things that we can do, that we have to do to take care of ourselves and our community and each other right now. Please, this country needs you. Your voice matters. Your vote matters. You matter.
So Justice Sotomayor said ex-presidents should not be above the law like if they're kings.
Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
He could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an
No,
unlawful.
because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we go back to
Johnson,
Justice Thomas's question, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet they didn't take it up. Instead, they pass an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. So, or you can impose criminal liability. We would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that, a president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable for a president or any public official to do that.
Your Honor, as this court said very persuasively in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the other court's cases.
So that was Donald Trump's lawyer arguing that he is entitled and should get immunity from prosecution because he's an ex-president. Justice Sotomayor did not see that particular point of view. But in the end, the conservative judges on the court ruled in favor of Trump that he is immune from criminal prosecution. So what does that mean for the case in New York that Trump was found guilty on? And DA Alvin Braggs brought in that guilty verdict. So I guess now, according to the Supreme Court, these jurisdictions have to revamp the sentencing, or if there is going to be a sentence, because remember, he's immune from criminal prosecution. So it's a dangerous precedent that they set. They have set the stage for crime in the White House. They have set the stage for immunity on all criminal level when it comes to the president. So he's been set up as the king, absolute power. I don't think that's what the framers of the Constitution intended.
U.S. Supreme Court. Sotomayor says immunity ruling makes a president king above the law. Stark dissent from liberal Supreme Court justice says decision will let presidents commit crimes with impunity. In a stark dissent from the conservative majority U.S. Supreme Court's opinion granting Donald Trump some immunity from criminal prosecution, the liberal Justice Sonia Sotomayor said the decision was a mockery that makes a president a king above the law. The court ruled Monday that Trump cannot be prosecuted for official acts he took while president, setting up tests for which of the federal criminal charges over his attempt to subvert the 2020 election are considered official and sending the case back to a lower court to decide. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency, Sotomayor wrote in dissent. It makes a mockery of the principle, foundational to our Constitution and system of government, that no man is above the law. Sotomayor, writing in a scathing tone, said the court would effectively allow presidents to commit clear crimes without punishment, an expansion of presidential powers that puts democracy at risk. She and fellow liberal Justice Ketanji Brown Jackson lay out hypothetical ways the court's ruling could create crises in the U.S. The President of the United States is the most powerful person in the country, and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution, Sotomayor wrote. Orders the Navy's SEAL Team 6 to assassinate a political rival. Immune. Organizes a military coup to hold on to power. Immune. Takes a bribe in exchange for a pardon. Immune. Immune, immune, immune. Let the president violate the law, let him exploit the trappings of his office for personal gain, let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. Until now, presidents have operated under the assumption that their actions were not immune from criminal prosecution if they used their office, and the trappings of their office, to commit crimes, she writes. But going forward, presidents won't be so concerned. With fear for our democracy, I dissent, she concluded. Jackson wrote a separate dissent, though noted that she agrees with every word of her powerful dissent, and wanted to lay out the theoretical nuts and bolts of what, exactly, the majority has done today to alter the paradigm of accountability for presidents of the United States. The ruling changes the balance of power among the three branches of government and gets rid of the ability to deter presidents from abusing their power, to the detriment of us all, Jackson wrote. The practical consequences of the majority decision are a 5-alarm fire that threatens to consume democratic self-governance and the normal operations of our government. In a footnote in her dissent, Jackson games out the oddity of deciding whether a president is immune from prosecution based on the character of a president's powers. While the president may have the authority to decide to remove the attorney general, for example, the question here is whether the president has the option to remove the attorney general by, say, poisoning him to death, Jackson wrote. Put another way, the issue here is not whether the president has exclusive removal power, but whether a generally applicable criminal law prohibiting murder can restrict how the president exercises that authority. While the majority opinion, written by Chief Justice John Roberts, claims it hems in presidential immunity in some ways, Sotomayor takes that idea to task. The majority opinion is an embrace of the most far-reaching view of presidential immunity on offer. No one has claimed that purely private acts would be immune from prosecution, she writes, making their exclusion an unremarkable proposition. The court effectively expanded what is considered an official act in a way that will capture events beyond a presidential's core duties and ensnare unofficial acts, she claims. And a prohibition on bringing up these official acts during a prosecution of unofficial acts deprives these prosecutions of any teeth. She lays out an example. For instance, the majority struggles with classifying whether a president's speech is in his capacity as president official act or as a candidate unofficial act. Imagine a president states in an official speech that he intends to stop a political rival from passing legislation that he opposes, no matter what it takes to do so, official act. He then hires a private hitman to murder that political rival, unofficial act. Under the majority's rule, the murder indictment could include no allegation of the president's public admission of premeditated intent to support the mens rea of murder. That is a strange result, to say the least. The majority wrote that immunity is necessary because it allows the nation's top elected official to execute his duties, fearlessly and fairly, and take bold and unhesitating action, without the threat of looming prosecution. But, Sotomayor hits back, it's more dangerous for a president to feel empowered to break the law. I am deeply troubled by the idea, inherent in the majority's opinion, that our nation loses something valuable when the president is forced to operate within the confines of federal criminal law. The testy dissent was replete with digs at the conservative-dominated court, which, aided by justices Trump appointed when he was in office, now counts just 3 liberal justices and has moved the country further to the right in recent years as a result. She said the majority invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The conservatives relied on little more than its own misguided wisdom, she wrote. She added that, it seems history matters to this court only when it is convenient. In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers, until now. Settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them, she wrote.
As you leave the page, don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. Thank you for watching.